Strikes are among the most powerful economic weapons in a union's arsenal. The NLRA balances the right to strike with various permissible employer responses. Let's consider what constitutes a strike. A union represented an employer's maintenance staff. During bargaining for a CBA, the union and the employer reached an impasse. To pressure the employer, the maintenance employees walked out one day, leaving the workplace and refusing to finish the day's work. The next morning, the employees returned to work. Was this a strike? Yes. Essentially, a strike is an organized refusal to work. A walkout is one kind of strike. A brief, temporary work stoppage is another. It's also a strike if employees refuse to report for work, either for a definite time period or an indefinite time. Strikes are protected concerted activity. Picketing can be an important element of a strike, but an action can be a strike without picketing. Picketing may increase a strike's effect on a struck employer if customers, suppliers, and other employees refuse to cross the picket line. What if, instead of walking out, the maintenance employees intentionally slowed the pace of their work? Would this activity be a strike? Here, the employees engaged in a slowdown or a partial work stoppage, which isn't protected activity. To qualify as a strike, employees must cease all work. Employees aren't entitled to remain on the job and continue getting paid while refusing to work. Suppose the maintenance employees stopped work completely but remained on the employer's premises. After the employer ordered them to leave, a few did so, but most refused. The employer then fired the employees who stayed. Did the employer violate the statute? Maybe. This example illustrates a conflict between the employee's right to engage in concerted activity and the employer's property rights.